When a government agency searches without a reason, it's called phishing. When the Attorney General of New Jersey issued a subpoena demanding the names, addresses, and phone numbers of the donors to a pregnancy center, it wasn't just phishing, it was searching for a white whale. So we'll take a look at this case next on the Constitution Study.
Neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution. Teach your action generation be free. Glad you could join me today. Fourth Amendment protections, your protection against unreasonable searches and seizures, the warrant requirement, are some of those cherished and important protections we have. So when government actors, whether they be attorneys general, Congress, judges, or just law enforcement officers, when they violate that, it's a big deal. But sadly, it's not often treated that way. This case in New Jersey, I think, is a perfect example of the abuse, the overreach of government actors, the lust of power that has become part of them. And you'll see as I get into the details. Now, if you want to double check my work, head to the website, constitutionstudy.com. You'll find all my sources with links to where I found them so you can double check what I'm doing here. I'll talk more about the website and some other things at the end of the episode, but for now, let's take a look at this case of First Choice Women's Resource versus New Jersey Attorney General. The Fourth Amendment protects us from unreasonable searches. However, that does not stop some law enforcement agencies from abusing their subpoena authority to conduct unreasonable searches. That appears to be what happened to the First Choice Women's Resource Center. Before we get into the case, we should define the difference between subpoenas and warrants. The criteria for a warrant is defined in the Fourth Amendment. No warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Now, according to the Free Legal Dictionary, a subpoena is a formal document that orders a named individual to appear before a duly authorized body at a fixed time to give testimony. Now, this distinction is important because, according to the Free Legal Dictionary, a duly authorized body can order an individual to appear without any probable cause. There's no need to provide reasonable suspicion that the person is, or about to commit a crime, according to the case Union Pacific v. Botsford. No right is held more sacred or is more carefully guarded by the common law than that of every individual to the possession and control of his own person, free from all restraint or interference of others, unless by clear and unquestionable authority of law. So where is the clear and unquestionable authority of law for a duly authorized body to search without a warrant? Where is the authorization for said body to seize by demand of attendance with the authority of a subpoena? As we'll see, while it may not have been the focus of much of the argument, this is the cornerstone of the protection of our rights. As usual, arguments start with the attorney for the petitioner.
Thank you, Mr. Chief Justice, and may it please the court. This court has long safeguarded the right of association by protecting the membership and donor lists of nonprofit organizations like First Choice. Yet the Attorney General of New Jersey issued a sweeping subpoena commanding, on pain of contempt, that First Choice produce donor names, addresses, and phone numbers, so his office could contact and question them. That violates the right of association.
Ms. Hawley's opening argument may be true, but I still have a problem with it. Yes, if the state of New Jersey can simply demand the information of people who associate with a group, then it violates their right of association. However, the First Amendment does not protect people from such violations by a state, only those done by laws made by Congress. The First Amendment reads, "Congress shall make no law abridging the right of the people to peaceably assemble." The Constitution of the state of New Jersey does protect its citizens. The people have the right to freely assemble together. Not only is this rather important detail missed by both the attorneys and justices of the Supreme Court, but lower courts had some interesting views as well.
Yet the lower courts held that First Choice must litigate its First Amendment claims in state court. That violates this court's decision in Nick, contradicts the court's virtually unflagging obligation to decide cases within their jurisdiction, and runs contrary to Section 1983. Even the Attorney General now agrees as much.
There is a serious constitutional issue with the claims of the lower courts. State courts do not have jurisdiction over First Amendment issues, only federal ones. From Article 3 of the Constitution, the judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority. So how can a state court litigate a case that the Constitution clearly states is under the judicial power of the United States, i.e. federal courts?
His newest rationale for evading review, questioning First Choice's chilling injury, fails for two reasons. First, First Choice's associational interests were harmed the moment it received a coercive subpoena demanding donor names on pain of contempt. This is true irrespective of whether the subpoena is non-self-executing, for even an unenforceable threat may chill First Amendment freedom.
There was a fair amount of discussion regarding chilling injury, that the actions of the New Jersey Attorney General chill the ability of the First Choice to acquire and maintain donors. We'll talk about that later.
Second, the Attorney General does not dispute that First Choice faces a credible threat of enforcement, and there's no question that First Choice's First Amendment interests are arguably burdened by the subpoena. This Court's cases require no more. The Attorney General's proposed subpoena exception from ordinary Article 3 rules would mean that the NAACP could have received a hostile subpoena from an Attorney General, and federal court review would not have been available until a state court ordered production. But then, Younger abstention and res judicata would almost certainly slam the federal courthouse doors shut.
The other major point of discussion was whether or not there was credible threat against First Choice. First Choice has a simple ask.
This court should reverse and hold that this subpoena violates the First Amendment and satisfies Article 3.
I agree that the lower court decision should be reversed and that the case belongs in an Article 3 court. But I disagree that the subpoena violates the First Amendment, because what it does is violate the Fourth Amendment. The Deputy Attorney General of New Jersey argued their case.
Mr. Chief Justice, and may it please the Court, Petitioner's factual allegations do not show that the issuance of this subpoena objectively chilled Petitioner's First Amendment rights.
Funny that Mr. Iyer claims that a subpoena threatening contempt if First Choice doesn't comply does not chill their rights. I agree. It doesn't chill their First Amendment rights, but it does chill their liberty to retain donors when they find out their personal identifying information has been collected by the state of New Jersey simply for donating to a particular nonprofit organization.
To some of the colloquies this morning about state law, New Jersey state law establishes that subpoenas do not require anyone to produce documents, and a party faces no penalties for non-production. Any legal duty to produce documents, and in this case, any disclosure of donor identities, is instead wholly contingent on a future state court order requiring production.
Interesting. If the laws of the state of New Jersey do not require complying with a subpoena, you would think the Attorney General's office would know that. Yet still, they include this language in the subpoena. Failure to comply with this subpoena may render you liable for contempt of court and such other penalties as are provided for by law. You have an obligation to retain and continue to maintain the requested documents. Failure to comply with this subpoena may render you liable for contempt of court and such other penalties as are provided by law. Yes, the subpoena says that First Choice may be liable for contempt of court, but the threat is there. Comply or else. Not to mention the legal cost of First Choice to attempt to quash the subpoena.
This case is a perfect illustration. The state court has repeatedly declined to order production over 2 years of litigation. That helps explain why Petitioner never alleged below that anyone actually has been or is objectively likely to be chilled by this subpoena. Instead, at most, the complaint alleges that the subpoena itself, quote, may cause donors to stop contributing. But that contingent language has never been enough for Article 3.
For 2 years, First Choice has had to defend themselves in court against what I will later show to be an unreasonable and therefore unconstitutional search of their records. As for Article 3 standing, as I've already pointed out, since this is a case arising under the Constitution of the United States, Article 3 courts are the only ones with jurisdiction.
The federal government's alternative credible threat of enforcement theory of standing is even worse. State and local governments issue tens of thousands of subpoenas every year. but the federal government's theory would risk turning many of these ordinary subpoena disputes into federal cases, even without a First Amendment claim. That would be a remarkable break from history and tradition.
Perhaps the tens of thousands of subpoenas issued every year by state and local governments, not to mention by federal agencies, should be reviewed. Where do these governments get the legal authority to compel attendance, to deprive someone of their liberty without due process of law? In some cases, to provide evidence without a warrant. That is a violation of the Fourth Amendment's reasonableness clause. It may also be a violation of the Fifth Amendment's self-witness clause.
No court has accepted that theory, and this court should not be the first, particularly in a case where the question presented was itself limited to chill.
While no court may have accepted the theory that a state subpoena violates the First Amendment, well, there's always first. As I said, I believe the court should be the first to consider whether or not subpoenas, specifically language used to compel attendance, violate the Fourth Amendment. During questioning, several interesting arguments were looked at. Let's start with whether or not a subpoena is a command or merely a request.
Your argument seems to be based on the mere reception of the subpoena. So what did that cause you to do?
Sure. So under the Article 3, we can have both a present and a future imminent harm, Your Honor.
But what did you have to do upon reception of the subpoena?
So the subpoena commands First Choice to do several things. It commands it to produce 28 different categories of documents, including every solicitation, email, and text message it's sent to its donors. It commands it produce donor names, addresses, phone numbers, as well as places of employment. It imposes a litigation hold, Your Honor, and it also chilled First Choice and its donors' First Amendment rights.
As I pointed out, this subpoena cannot violate the First Amendment since it's not based on the law made by Congress. However, by compelling that First Choice do something, the Attorney General deprived them of their liberty to privately communicate with their donors. That violates the 14th Amendment's Due Process Clause. Nor shall any state deprive any person of life, liberty, or property without due process of law. Remember, under the Fourth Amendment, any search must be reasonable. Now, there are circumstances where a search can be reasonable without a warrant. There has to be some basis for reasonableness.
Were there complaints against you that stimulated the subpoena?
No, Your Honor. The Attorney General has never identified a single complaint against First Choice.
If there's no complaint, what is the reasonable articulable suspicion that a crime has been committed? There isn't one. So what makes the search of documents that a subpoena is demanding reasonable? But is a subpoena nothing more than a request?
Did you view this as a request? The briefs of the Attorney General seem to suggest that this is, I've never heard the term subpoena request, but did you view this as a request?
Absolutely not, Your Honor. This is not in the record, but First Choice immediately convened an emergency board meeting to discuss the subpoena. The very Latin term for subpoena means under penalty. If you look at the face of the subpoena, it twice commands First Choice to produce on pain of contempt, and it twice threatens that the failure to comply with this subpoena, not a later state court order, but with the subpoena, shall render First Choice liable for contempt and other penalties at law. Some of those other penalties at law are business dissolution. That is a death knell for nonprofits like First Choice.
Having received a federal subpoena, I can tell you there is nothing about that process that leads you to believe it is a request. Now that I know that a subpoena is Latin for under penalty, I'm sure it's not a request. During questioning of the respondent's attorney, Justice Thomas asked the same question.
What is the difference between this subpoena and a request?
Your Honor, this subpoena is a predicate under state law for the state executive branch to be able to go to a court to seek a court order requiring production. We couldn't do that if we had just sent a letter request. But in other critical respects, there's really not a difference in terms of the legal obligations that are actually imposed upon a recipient of a subpoena.
Funny, when a district attorney seeks a court order to compel attendance, I don't think they issue a subpoena first. Does law enforcement, part of the executive branch, seek a subpoena before seeking a warrant? Mr. Iyer went on.
Typically, when we think about subpoenas, we're thinking about grand jury subpoenas or subpoenas that are issued by a court during civil litigation. I think an administrative subpoena is very different, and courts, as a matter of state law, have held across the country that these subpoenas themselves don't impose any obligation to produce documents from the moment of the issuance.
So a document literally titled under penalty does not impose an obligation to produce documents under some penalty? Does that sound reasonable to you? If there is no obligation, then why does the subpoena use the term compel? Justice Gorsuch also asked about the power of subpoenas.
And just looking at the statute, it says the AG subpoenas have the force of law. And if a person fails to obey the subpoena, the AG may apply to the Superior Court and obtain an order adjudging such person in contempt of court. Now, I don't know how to read that other than it's pretty self-executing to me, counsel. Now, maybe that's anomalous. Maybe that's wrong. Maybe the New Jersey Supreme Court's read it differently, but that's not the materials I have before me, so help me out.
Absolutely. So we think there are a number of reasons why these subpoenas need to be understood as non-self-executing.
The state of New Jersey claims that a subpoena is not self-executing, meaning someone cannot be held for violating it, but state law says a subpoena from the Attorney General's office has the force of law. So which is it?
Ms. Hawley, I'm sympathetic to the argument that the subpoena on its face looked like it carried penalties based on everything that you said, but I think we have to accept for purposes of this case that it's non-self-executing, and so that it did not, in fact, at the moment of receipt, demand that you reply on pain of contempt to send you a subpoena that will demand all of these documents, or just a letter requesting them that wasn't a subpoena. Please turn over to me all of these documents. Would a letter have been sufficient then for ripeness under your theory? What if he had just sent a letter saying, I intend to send you a subpoena that will demand all of these documents, or just a letter requesting them that wasn't a subpoena? Please turn over to me all of these documents.
Think about that for a second. A letter stating you're going to be sent a subpoena to demand documents that aren't really a demand because the subpoena is not self-executing and requires a court order to be legally enforceable. Does that make sense to you? Besides, the AG didn't send a letter. They sent a subpoena that stated, you are hereby commanded to produce to the New Jersey Division of Consumer Affairs, Office of Consumer Protection, through Chanel Van Dyke, Deputy Attorney General, at 124 Hazley Street, 5th floor, Newark, New Jersey, on or before December 15, 2023 at 10 a.m. the following. Does that sound like a non-self-executing request that needs a court order to be enforced? No, it sounds like a demand to produce documents to be searched without a warrant, exigent circumstances, or even a reasonable cause. That, ladies and gentlemen, is an obvious and blatant violation of the Fourth Amendment. As I've already pointed out, this cannot be a First Amendment violation, but a Fourth. Justice Barrett opened that door in her questioning.
Are we only talking about First Amendment cases? Are we talking about other constitutional challenges?
I don't see a way to limit the United States' proposed rule just to First Amendment challenges. I think it would encompass Fourth Amendment challenges, to Justice Sotomayor's examples earlier, due process challenges, extraterritoriality challenges.
Yes, let's challenge Fourth Amendment and due process in both the Fifth and 14th Amendment. Lots and lots of challenges. But is the purpose of the court to make the government's life easier or to seek justice under the law? It seems to me there are far more constitutional issues with the use of subpoenas, especially the way the New Jersey Attorney General has than questions of association. I hope you see why I decided to dive into this case. It's bad enough that the attorneys brought such a poorly formed case, but the fact that no one pointed out the blatant Fourth Amendment violation is truly disturbing. Having received a subpoena, I know the impact of the words compelling you to attend or provide evidence. In my case, it was a command to testify in a case. In First Choice's case, it was to provide confidential information about their donors. Yes, this would certainly give donors pause, chilling their association with First Choice. But to me, the greater harm is the loss of protection for both First Choice and all Americans of our right to be secure from unreasonable searches and seizures. I doubt the court will publish their decision before June. I can only hope that the justices will see beyond the focus on First Choice's Attorney General of the First Amendment and focus on our right to be secure from unreasonable searches and seizures. This has got to be one of the most frustrating parts of my job. I wish I could be in the court and raise my hand and say, no, honors, this cannot be a First Amendment. Congress did not make this law. This violates the Fourth Amendment, the Fifth Amendment, the 14th Amendment. But I'm not there. I'm not allowed to be there. I can sit in the gallery and be quiet. No one would accept an amicus brief from me. I have no input. All I can do is bring it to your attention and hopefully maybe spread the word so that more people start asking these questions, which to me are blatantly obvious. It's like waking up in the morning and seeing the sunshine and go, oh, it's still nighttime. I mean, it's really, to my mind, kind of crazy how bad our legal system is, how bad the attorneys have been trained and our judges have been trained, that they cannot see the forest for the trees. Saddens me. I can hope that this court comes to the right conclusion, but I'm pretty sure they're going to do it for the wrong reasons, because they're going to ignore the Fourth Amendment. They weren't asked about the Fourth Amendment. They weren't asked about the Fifth Amendment. They weren't asked about the 14th Amendment. They were asked a stupid thing about the First Amendment, which this plainly cannot violate. What are you going to do? I know what I'm going to do. I'm going to keep reading and studying and focusing on these so I can bring them to you so that you have a better idea of what's going on. Now, if you'd like to help, if you'd like to join me, head to constitutionstudy.com. I've got lots of resources there, my articles, my videos, my sources. I have news links that you can follow. You can sign up for mailing lists. There's lots of information there. And if you'd like to help support the work we're doing here, and nobody here takes a salary. We don't get paid. We pay for all of this. And if you'd like to help, we'll go to constitutionstudy.com/shop and hit the donate page. Make a one-time or recurring donation. All of that money is used to keep this place up and running. And I could certainly use the help. Now, you can also help me by using your cell phone. See, Patriot Mobile is America's only Christian conservative wireless provider. If you join them, you're supporting organizations like the Constitution Study that are defending your rights. Just go to patriotmobile.com/constitution, find a plan that works for you, see if you're eligible for a discount. I mean, everyone from first responders to families with multiple lines and many more are eligible for a discount. So you get a good price, you get good coverage, you get good customer support, and you support organizations like the Constitution Study. And oh yeah, if you use the code Constitution at checkout, you can even have your new line activated absolutely free. So again, head to patriotmobile.com/constitution, find a plan and discount that works for you, and don't forget to use that code Constitution at checkout to get your line activated absolutely free. Most of all, please share this episode, share the work that we're doing, and hey, maybe invite a few friends the next time we get together for the Constitution Study.
Love your neighbors and have a few good